Today, the father of the suspected Georgia school shooter and the teen made their first court appearances. But there were several eye-raising issues this morning, including the moment the judge had to bring the teen back into the courtroom on an issue of a possible death penalty. Chief Legal Analyst Khalif Rhodes joins me now. So Khalif, the teen was informed this morning that his felony murder charges would be punishable by death, but then the judge called him back in 10 minutes later in reverse course. Any insight into what happened there?
That judge was obviously doing repetition. We're creatures of habit. And so I listened to the hearing. I watched it and I could hear him. He was just going through his normal process. You get a person that's in front of you. They're charged with a felony murder. They're charged with some type of capital offense where you're in a state where the death penalty is an option, which Georgia it is. He's reading the process. You're charged with a capital offense. Do you need counsel? He addressed counsel, and then he talked about possible punishments because a person has an opportunity and an obligation by the Constitution to know what they're charged with and know the maximum punishment. He told him that. Then he realized, wait, hold on, this is a juvenile. Because these situations don't normally happen, there's a Supreme Court case from 2005 that removed juveniles from being allowed to have the death penalty. Cruel and unusual punishment, obviously, is what they cited during that time, 5-4 decision, but the court outlawed it back in 2005. And so because this is not his daily repetition of saying, okay, you're not subject to it, he just was someone probably reminded him in the back, and then he had to bring him back out.
Is he being tried as an adult in this situation? So would that impact this?
Even if he's tried as an adult, regardless, once he is convicted, if he is convicted at trial or takes some type of plea, there is no opportunity for a person convicted that is a juvenile. And the cases that they talked about was a 16 and 17-year-old, specifically a 17-year-old, their case, they had a death penalty because at the time there were 71 folks on death row that were juveniles, and that was in 05. But now no more, so that can't occur. So in that situation, that was just a misstep. I assume that someone helped them in the back.
Okay, want to talk about another moment that happened in court today for both the father and their son. Their attorneys both said that they would be receiving new counsel. Does that happen very often, or what happened?
It does, and so I actually did my externship in Georgia in the Fulton County Public Defender. That's in Jackson County where this happened, but the system in Georgia is the exact same. Those two were represented by the Public Defender's Office. The judge during the hearing said, listen, if you want to get new counsel, you can do that. But at some point when he was talking, another woman from the back, kind of off camera, said, well, we've already informed them because there's some developing in situations, they're going to need new counsel. Typically, that's when there's a conflict within the office or within that department. And so when I have multiple defendants, and multiple defendants or co-defendants in the case, the Public Defender's Office may represent one, but then they may be conflicted out to represent a couple other individuals. And so then I would maybe pick up someone as a retained attorney, and then they'll have something else called a conflicted out attorneys division. In Georgia, they have that handle cases specifically where the Public Defender's Office can't handle it. Someone retained has to handle it, and they need assistance. I'm assuming they're going to move to the conflicted out retained attorney type.
Okay, so both refused bail. Now will remain behind bars until December 4th. So what do the next 3 months look like?
A lot of sitting and waiting. When I meet with clients, I tell them, at least in Mecklenburg County, you can look at a homicide case will take between 3 to 5 years for it to take process. And it's normally really, really fast. You get arrested, they go through the intake process. Then there's a whole lot of waiting. You're waiting to get discovery. You're waiting for the state to make a determination on how their case is going to go. So it's typically a lot of waiting. In these smaller type of counties, you get information a little bit faster. But because it's a homicide case, because you have so many different agencies involved, it's going to be a lot of individuals looking and putting their hands on this case. So them getting that discovery, all of the information, taking it and giving it to the DA's office, then the DA's office looking at it, and then taking it and giving it to the attorney's office, that's going to take a long time. So I would anticipate a number of months. They'll have multiple hearings. This case won't go anywhere for a while.
And probably a lot of meetings with their attorneys as well, going over all of that.
For sure.
Khalif, thank you. Another big legal topic is now parents being charged in the wake of these school shootings. We're going to have you back at 5:30 to dig deeper into that topic.